February 15th meeting of the City of Lake Stevens Planning Commission.
Mike, can you get a mic near you?
I can share. February 15th meeting of the Lake Stevens Planning Commission is now called to order. We have the roll call. We're all here except Connor Davis. Can we get a motion to excuse him?
So moved. I'll second.
Okay, all in favor?
Aye.
Aye. So moved. Item 3, guest business. Do we have any guest business for the commission tonight on items that are not on the agenda?
Is there anybody online?
There's 2 people that are not online. They have not raised hands yet.
Okie dokie. Oh, did we not? Oh, we didn't have the Pledge of Allegiance on here.
Well, let's
Let's do that.
back up.
Poke me. All right. I pledge allegiance to the flag of the United States of America, to the republic which stands one nation, under God, indivisible, with liberty and justice for all. All right. So our next item, we're actually going to move the public hearing, item 5, into our next spot, which is the Shoreline Master Program. So at this time, I think we'll open the public hearing. Any comments on that?
Okay, so thank you, Commission. Tonight, we're going to do the public hearing for the minor shoreline master program update. The Planning Commission looked at that a couple of times last year, and the intent of the update was to encapsulate the recommendations from the waterfront residential community and remove any inconsistent language out of the shoreline master program as it relates to multifamily housing. So on page 2 of the staff report as it relates to to the shoreline master program, there's a series of bullets that just describes the changes. Those are also shown in attachment 1. So just very minor changes. And the other change was to update the reference to the current critical areas regulation. When the last shoreline master program was updated, we were just in the middle of finalizing those critical areas ordinance. So they do reflect the same language. It's just now the actual ordinance number is attached. Beyond that, we went through a joint review process with the Department of Ecology, who held a joint hearing with the Department of Ecology in December. We've gone through the final steps for public notice. We've not received any comments after either the joint hearing process or the SEPA process. So now we're continuing the local adoption process as defined by our code. And this would be the first hearing with the Planning Commission, and then City Council would also hold a hearing on this, and then the ordinance would be adopted. So again, just 2 sets of minor amendments. 1, to remove any language as it relates to multifamily housing in the waterfront residential zone, and then 2, to update that code reference for critical areas. I'm happy to take any comments or questions from the commission.
Commissioners? No? No? Any comments from the public? It's for the public hearing?
Public comment.
Yeah, we
We
usually,
need to vote to.
we usually discuss and then we open for public comment and then we discuss again.
All right, so let's open the floor for public comment. We need a vote?
No, you
Just open it up. Okay.
Just ask if anyone.
Is
online-
anybody online have any public comment? No. Okay, then we'll close the public comment. Any further discussion from the commissioners?
I have none. I think it's pretty much just fixing some language that's really not major.
Yeah, I think we've seen this in part before. Okay, then I think our next move here is to vote to close the public hearing.
So I'll second. Sorry.
All those in favor of closing the hearing?
Aye.
Is that,
Then an action, look for an action.
so the next phase then is do we have a move to adopt the
shoreline master program.
I'll make a motion that we recommend the shore management plan as submitted by staff.
I'll second.
All those in favor?
Aye.
All those opposed? Hearing none, motion carries. And that puts us on to what had been a label on the agenda as a discussion item and is now action items. Russ, I didn't see minutes on here. Did we have a need to approve any minutes?
We didn't get the minutes from our last meeting in the packet, so you will.
So we'll carry those.
Those are the next meeting.
Okay. So let's move on to discussion items. Discussion item A, the
If I may, Chair, is it appropriate for me to reach out to whoever's going to do the minutes prior to creating those? And the only reason that I asked that is that there was a proxy vote that I had sent in. I'm wondering whether or not that was countered into our last meeting. I wasn't here. Can I reach out for
Sure.
the draft
And
on that?
just give those comments right now to Cody is totally fine and he'll make sure they're included.
Okay, Cody. So I made a proxy nomination, two actually, in our last meeting. I did that twice via email. And then during the meeting, I understand that it was there was discussion during the meeting. So I don't know if that information via email was done. And the only reason I bring this up is that with us having somebody excused tonight and a new planning commissioner yet to be announced, I want to make sure that those of us that are here are able to be heard, whether or not we're sitting in this room, so that we always have a quorum to move forward on some things. I appreciate that. Thank you so much.
Okay, on to discussion item A, 2023 comprehensive plan docket briefing. Planning Director Wright.
Okay. So this is nothing new to the Planning Commission. Every year we go through the annual docket update. Sometimes to make minor changes to the comprehensive plan, sometimes to make slightly larger one. This year would be a set of minor updates. So there are a couple of map amendments for your consideration. The first we're calling M1, and that is to change the land use designation and zoning for the property that we call the Cedarwood property from medium density residential to public semi-public. That's consistent with the park plan after the acquisition of this property. And we're just trying to get this property ready for redevelopment for park and recreation purposes. So that would be the next step to do this. M2 is a little interesting, as the Planning Commission and City Council had their deliberations over the parcels on 97th that the Planning Commission had championed to go back to residential designation. There was a pending property sale that we found out after adoption of some folks that had bought a property for commercial purpose and were intending to open a business there. And that would be the farthest southwestern property. So it immediately abuts the other commercially designated properties off of South Lake Stevens Road and SR 9. So just coming back to the Planning Commission to ask if you want to reconsider for that single parcel to go back to the commercial designation. I equate this to when you looked at the commercial designation change further up on 20th Street, where you had talked about expanding the boundaries, and the one property owner said, I would like to be excluded from that, and the commission did that. This is the same sort of thing. Had we heard from this individual, we probably would have made a recommendation to the commission to exclude this property as well. Beyond that, we have some minor text amendments that will affect the capital facilities plan, and then just all of the standard footnotes, table of contents, and purely administrative housekeeping updates that will go along with this. We also have one citizen initiated map amendment, and these are for properties off of Lundin. In 2008, these properties, two properties had been designated as mixed use. The owners of the property, according to their narrative, have tried to sell the property over the years. But due to the significant encumbrances of Lundin Creek, associated wetlands, the site just hasn't really been viable for a mixed use type development. It is a very narrow property, so there would be a lot of constraints, and they are asking if they can go back to a residential zoning designation. They would just like to keep the property and the family for now, and then look for potential residential development on the site in the future. So that's the list of amendments for this year. Like I say, pretty limited scope. I'd like to get through the amendments probably by May or June of this year, if possible, just so we can focus on the 2024 docket, which is going to be much more intensive. And so just looking for feedback from the commission tonight on these proposed docket items. And if you're generally in agreement, we will bring these forward to a public hearing on March 1st, where you can then actually forward a recommendation for future and additional study on these, and that will go to the city council for their action.
Okay. Any discussions or questions?
Well, I guess I'll start with, I'll jump real quick to map 2. Just because since that's the one we kind of forwarded, that's that one piece of property. I think if we had known, because that one's not on the road we were really concerned with. I think probably because that's commercial on Highway 9, right?
Yes,
So this is just a property or so in, but it's not on that.
it's not on 97.
97 is what we were concerned with, this one
Yeah.
just next to it.
Mhm.
So I personally don't have a problem with it. I guess I wish it hadn't gotten cut with this last one. It's like cutting.
All of
it's
us.
like trying to use an X-Acto knife to little cut it through there. I think the more concern was to make sure that 97 was residential, so I have no problem with that being commercial again, or, I mean, unfortunately, do they have to wait till we do this again in November?
Right.
Yeah. So I have no problem with map 2 at all, that just moving it over until it takes over that property, but not enough where it gets on the next over, which would be 97.
Correct.
I feel like I just want to say again for people who are listening who are not part of the commission, just restate the obvious, which is that what we're doing right now is deciding what will kind of be our docket for going forward. We're not
Correct.
making decisions.
No
by any
decisions are
means.
being made.
And so having made that clear that what we're doing is setting the agenda, that I am for this greater discussion and evaluation of all of these.
Okay.
Good to me.
And I appreciate you delineating that, because I disagree with Commissioner Welch. And I would like to look into a little bit more of where we are X-Acto knifing and why. And so I look forward to the discussion of M1 as well, because that's been a big topic around the community. So that will be something that I look forward to hopefully input from the community on. One question on the property owner that is the citizen initiated. When they bought in 2008, was there anything different on that property that is there now?
They didn't buy it in 2008. They've been an owner, a longtime owner of that property, has a single family home on it. So no, the condition of the property has not changed.
Okay, so the only thing that has changed is the zoning on it, or their ability to do something on it. But there hasn't been anything redirected. There hasn't been anything
Nothing has
dammed
changed.
up. I'm thinking about, what Costco did to the culverts and everything down in that area. So if there is something that has happened to that property since they have been on it, that I would like to be aware of that before we go into further discussion. Okay, thank you. Clarification is
So
good.
we're just adding this to the consideration for the comp plan, these 3 things, right?
Correct.
Because we'll get more information, because obviously we want to change this from mixed use. I'm sorry, the citizen initiated one, from mixed use to R8, R12, and there's gonna be a lot of studies to make sure that that property can handle a R8 to 12 designation, correct?
Right. So it would actually be a less intense designation than it is currently. Currently, the mixed use would have a minimum of 15 units to the acre.
Okay.
And it could go, 45, 55 feet in height. So it's a much more intensive designation now and would be topped out at the, 12 units if they wanted to do attached or less if they're doing detached units. So it's much less intensive
Okay.
designation.
Thanks. So, I think,
No, I'm fine.
I think they're all pretty important. I think we should definitely move forward with them all, getting more information, obviously getting more information to make sure they're adding to the docket and getting all that. Spending staff time on these projects.
Yeah, and I would agree. It's worthy of for further discussion. So I would be in favor of adding it.
When would we be seeing this?
March 1st.
It's quick.
That's about your standard turnaround for looking at dockets and then your hearing.
Okay, that brings us then to discussion item 4B, the short-term rental update.
Yeah. So I'll go ahead and start out, give a brief summary of kind of what we discussed at the subcommittee and the extensive history of this process. So the purpose of this amendment was to minimize public nuisance, preserve the availability of housing, and then to allow property owners to permit regulated temporary accommodations. So over the past 2 months, the citizen subcommittee has been really hard at work formulating a draft, which has been included in attachment 1 of this packet. Commissioner Dewar has really kindly agreed to give a brief summary of the discuss, go over what's included in the draft. Before I do pass on, I'll go over the history of this code amendment. So the process started about a year ago. We introduced this to the Planning Commission originally. We had held 3 work sessions with the Planning Commission and then ultimately moved it to the public hearing in which you forwarded a recommendation to City Council that supported only hosted rentals. The City Council then held 2 more work sessions where they reviewed the draft, but they were ultimately concerned with the restrictions on the unhosted rentals, the party size, and the inspections requirements. So we reached out by a letter to the property owners currently operating short-term rentals within the city at that time, and we gave them the opportunity to provide feedback. So the council then decided to form a 3-person subcommittee made up of 3 council members to refine the regulations further. Then they held 3 more public hearings and 3 more work sessions to discuss the drafts. At the most recent public hearing on November 15th, they passed a motion to create the most recent subcommittee, the citizen subcommittee. And that was composed of citizens, planning commissioners, and city council. And so they held 4 meetings during the months of December, January, and February of this year. The agendas for each of the 4 meetings are included as attachment 2 in the packet. So in the discussions, we discussed items such as unhosted versus hosted rentals, which is kind of the big topic. The permit process, the noticing involved, also separation requirements and a cap on the number of total short-term rentals within the city. So all the public comments are included in this packet. They're roughly from oldest to newest. So we received a bunch of comments, a total of 27 unique commenters, 9 of which were in favor of hosted rentals and 18 of which that were not. The city attorney also had the opportunity to review the draft and provided some feedback from which we have incorporated. It is kind of important to note that the Fifth Circuit Court of Appeal decision upheld the regulation that can require someone to occupy the property full-time. This doesn't necessarily need to be the owner. Washington is not within the Fifth Circuit, but the proposed code is still consistent with this finding. Russ, is there anything you wanted to add before I pass it off to Commissioner Dewar?
Just one clarification, the Fifth Circuit ruling found that you can't put owner occupancy requirements, strict owner occupancy requirements, because that would invalidate the Commerce Clause. The Ninth Circuit found you could have owner occupancy requirements with limitations, and that's more of ours is modeled after that. You can have a host that is the owner or the owner's representative. So the regulations as drafted would be consistent with both of those court opinions.
And Washington's in the Ninth Circuit.
Washington is in the Ninth Circuit. Beyond that, no, Jill, thank you. It's been a long process. All of the questions that you've asked, city council obviously deliberated on those. The advisory committee also tackled a lot of the same questions that you looked at, and they had the opportunity to look at all of the information you had looked at, the information that the city council had looked at, and deliberate, as well as look at some new material that you haven't seen, additional codes that had been recommended, different ways to think about this. So I would say at this point, the code as drafted really reflects the goals that came from the planning commission, the city council, and this advisory group. That was really the intent, to try and meld all of these different ideas and opinions into this hopefully definitive code. And with that, happy to turn it over to Commissioner Dewar to give his perspective as being a member of that advisory committee.
Yeah, thanks, Russ. I think it was very well covered right there. I would say that among the concerns, that we had, because we had some members of that special committee who were council members, some members were planning commissioners, some people owned short-term rentals, some people lived adjacent to them. So it was a very good selection of folks in the city. One of the big concerns that people have was what to do about these short-term rentals when they become a nuisance. And we had a great deal of conversation about how to provide notification, what sort of process is involved with code enforcement and law enforcement in making sure that these nuisance properties are dealt with. We also had, by the time we finished our work, worked on the concept of a cap of the number of these short-term rentals within the city, so that they can't completely take over neighborhoods, completely take over the waterfront. So that was also a recommendation of the group. In the end, one of the things I think that really colored the output of that committee was some of the legal landscape that governs what we can and can't do in a more, we'll say, risk-averse fashion that was recommended to the short-term rental committee. And with that, and with the refinements therein, we have then brought back to the planning commission the body of work as recommended by that group. I think everybody had a chance to be heard. I don't think anybody's 100% happy with the way it turned out, but perhaps that's the sign of good discourse. And with that, I think that's a brief summary.
And then I'll just turn back to some specific changes. So as we went through it, what was really important to the subcommittee, and if you look at page 28 of your packet, code citation 44064A1, getting that purpose statement was really important to this group. And fundamentally, they wanted to express the idea that if these are occurring in residential areas, they should be residential in character. That's why it was very important to this group to make the distinction between hosted and non-hosted. They all felt that when it went to non-hosted, that becomes more of that corporate ownership that really spoke to the absentee management that they had really concerns with. Also, more discussion on what is the effect to housing stock came out of that group. That's also reflected in that purpose statement. And it's also though reflected that, there are private property rights and people should be able to develop and get supplementary income off of their properties with reasonable limitations. So really, that was sort of the goal of this refined purpose statement, to capture those broad ideas. I will say today at a housing meeting I was on with Puget Sound Regional Council, they've also emphasized that probably in our upcoming comprehensive plans, we'll need to be thinking about of the impacts of short-term rentals on housing stock and just make sure that we're able to set reasonable goals and targets.
Can I ask a question?
Absolutely.
So it sounds like the inclusion of a cap is sort of forward thinking, with regard to what the Puget Sound Regional Council is going to be asking for going forward.
Yeah, not there's no direct correlation, but it's probably,
Thematically.
yeah, thematically, it's aligned and a lucky accident and it's not, other communities have tried a cap before as well, so. Some of the other things as we go through the code, the restrictions are actually fairly similar to what you looked at before. You need to go through a permit. It carries through the ideas that the short-term rental shouldn't be doing double duty for other types of home occupations, especially those that could create large gatherings. The licensing and registration is very similar to what you've seen before, with the exception it adds a separation clause. That's something you've also done before in terms of businesses that may affect elementary schools or parks, like if you look at cannabis or alcohol. Also, when you looked at mobile food vendors, you put some restrictions to make sure there was separation, so there's just not any oversaturation. So that was included. Some of the recommendations you'd had before about the contact information and how to provide that carries through. The written notification to neighbors and making sure that that is consistent and updated. The basic health and safety standards that you had recommended also were here through a self-certification process, and that was important to the city council. The duration that stayed 1 year, an annual renewal process. And again, then they have to verify that their contact information is current. One of the things that's new is determining, and this is aligned with sort of the court decisions, is what is the residency requirement? So we sort of came up with 240 days that it has to be occupied by the owner or the owner's representative. Then it's not an overly stringent regulation that people can't go on vacation, they can't travel, can't do other things. But if they are out of the premises, they do have to have a local contact. So that's something a little different than the way you had looked at it. Parking requirements are very similar to what you had recommended. It pulls in the state statutes to make sure that there's also that these units would be compliant with state regulations. There is a section on permit modifications that if there are unforeseen things that come up, then they have a method to petition to loosen some of the standards. What is new, and the subcommittee, actually all of you, city council subcommittee, everyone has spent a lot of time on this, trying to define what a nuisance activity is, since that gets to the heart of the question where we had so many of the citizens were concerned about what is the effect on my property. The city council's approach had been, let's just try to provide references to other code sections. But as we continue to have that discussion, we understood that it was a more important issue to people. And we did find a code in Encinitas, California, had a really good section that clearly defined nuisance activity. So we took that, we amended it, made it fit this code, refined it a little bit, but really decided to take on the idea of nuisance activity head on. And what does that mean? So it's, raucous behavior, loud noises, and really tries to be descriptive in what that means. So it doesn't go, say, to our nuisance chapter where it's going to say, if a noise is at such a dB, a decibel level, and carries, so forth, something we just will have a harder time understanding. So it puts it in plain words. What is the nuisance activity? If it occurs, then does that, can that be a documented violation? So that was important to this group to sort of clearly define that. And then how is the owner responsible then for nuisance activities through the enforcement process? So that's tied in that nuisance section as well. In the complaint section, it's very clear that any applications that come in under false pretense or with that aren't accurate, those are grounds for revocation of a license or a permit. The definitions have been expanded to try to capture a lot of different scenarios. But like I say, the general flavor of the ordinance blends the work of all of these groups. So we'd really love to hear what the Planning Commission has to say about the rules as drafted. Jill, did you want to add anything else before we hear from the commission?
No, I think you covered it all. Thank you.
Russ, I think the one thing that might be helpful is how we honed in on that 30 number. And as I recall, when we did a count, just for the benefit of this group, when we did a count of VRBOs available in Lake Stevens, the total count was, I think, 28. Is that accurate? So if they all became legit today,
I have a question about that. Of the 28 at that time this was being observed. A, how many of them were licensed under this existing code? And B, what's the process for getting everyone into compliance and license? Is there a time period that they'll be allowed?
So
6 months or
we have
7 months?
one licensed STR. Throughout the course of last year, we've started enforcement action against all of these STRs that are operating without a license. That started out last summer with some friendly, hey, you may not know, and it was more of a wait and see approach, waiting to see how fast these regulations were going to get adopted. Obviously, that slowed down. So then we went to the next step, which is, hey, you got to stop operating because you're out of compliance with city code. So they've all been notified. I believe majority of them have ceased operation, and a couple of them have come in to start an application through what's called our tourist home process. So we're working towards compliance. The end goal will be, though, outside of these regulations, I plan to draft a portion of the ordinance that will be a bridge. So if someone were to come in today and apply as a tourist home, I do want to create a provision in the ordinance that would allow them a period of time to come in and reapply to get that license transferred to a short-term rental if they can prove consistency with whatever the new rules are.
Until number 31.
Yeah.
And how many of those 30 to be number C or letter C on your question? How many of the 27 are waterfront versus anywhere else? Do we know the ratio?
I don't know. Do you know that, Jill?
It's probably close to half and half, I would guess. Last time I looked.
So, again, well, let's put a pin in that and I'll bring up some comments in a minute. Thank you, though.
did I see Connor Davis just join us on the call? Welcome, Connor.
Yes. Hey, guys. Yeah, I am in between conferences with parents, but yeah, I was able to jump on.
Connor, did you want to add anything from your time on the STR committee?
Yeah. Can you guys hear me properly? All right. Awesome. So, yeah, and Mike, I shot you. I realized it was still sitting in my drafts. I just shot over to you the synopsis. So I do apologize for that. My biggest takeaway from the SDR committee was that we were really taking the some of the best code from neighboring municipalities, kind of encompassing it in what is in front of the commission. A lot of the, some of the issues are around just how this could grow exponentially. That's where that idea of a cap came from. I know that Mike, you had discussed. Let me turn my camera on. Putting a medallion, kind of concept. But at the end of the day, settling on I think at the high end at 50, with no more than 10 around the lake. And I heard that there's perhaps up to half of the existing Airbnb VRBOs that were on the lake. I thought the last time we had looked at that last STR committee meeting, there was 5 or 6 that were actually on the lake. There were some with lake views, but that maybe 5 of them established current VRBOs or Airbnbs actually had lakefront property. Bottom line is that I thought that we came up with a and do the work of Russ and the team, really good comprehensive plan that could very well get the votes necessary from council, which is really the end goal at the same time.
All right, thank you.
And were you able to, Mike, provide just some of that, variation on the synopsis or to the commission?
Yeah, I think we got you covered.
All right, awesome. I really appreciate that.
So with that, are there any questions or comments?
I have one more
Sure.
question. I just wanted to ask quickly about the enforcement. Escalating here.
Progressive enforcement.
Yeah, the progressive enforcement from the code, section 17. Just curious what that looks like. Do we have section 17?
No, that's an existing code citation. So what the progressive enforcement means is the first step is education and looking for voluntary compliance. If we can't get voluntary compliance, we would go to a notice of violation. If through a notice of violation, there's not a remedy, then we'll go to a penalty phase. Penalties can be monetary penalties, or it could be at that point revocation with a criminal license.
I have a couple of questions. I'm gonna limit my questions because we'll just say I don't like the code much at all, but I'll go with some of the ones I think that are more realistic to look at. The 240 days. How's that checked? How's it even enforceable? On how long somebody's at their residence?
At the end of the day, it would be.
It seems
just-
like an unenforceable number.
Yeah, it's a self-certification. I mean, again, going back to, they're going to be signing an application and saying these things are true and correct. We're not going to be checking that most likely. If it comes to our attention, we will look into it, but you're right, it's one of those things we would have to accept. And again, the goal is to find a number that is consistent with where the court rulings are and number that is in the residency of the codes as well.
And we put in one of the documents, I think, for the one where you have to notify your neighbors. That if, basically, if you said you did and you didn't, it's in lieu of perjury.
Mhm.
Are we literally gonna throw people in jail if they lied about telling their neighbors? So that's what perjury is, a criminal, so we're gonna send law enforcement to the door, knock on the door, and take a human being to jail for committing perjury. If they lied about telling their neighbor that they got a short-term rental.
Yeah, it would be one of those.
I mean,
It
that's a-
would
that's a-
probably
That's
result.
literally a criminal charge that we're laying there. We're gonna.
Yeah.
What else we got? Oh. Excluding no more, let me go to section. Sorry about that, I got a lot of notes here. Section C, sub 3. No more than 2 guests excluding children under the age of 6 per bedroom. So we're limiting, multiple kids in a bedroom beyond 2 at the age of 6.
So 2 adults and then
They're,
kids
Small
under the age of 6, so they're small
So if you
children.
had like 2 sets of bunk beds in a room, all the children must be 6 or under. You can't have like 8-year-olds or 10-year-olds. Or so much and so forth. It's like, I read that as basically saying that. If you bring your family and you've got 14, 12, 7, 5, you got to have several bedrooms instead of just putting all my kids in one bedroom. Because we put that number 6-year-old on there.
right, that is essentially what it's saying. There are some reasons you want to define children of a certain age that are more closely dependent and 5, 6 is kind of a common breakpoint that we've seen. But the idea is you can have a couple and their children in a room, and beyond that, then additional bedrooms would be required to facilitate part of the service.
I have a couple comments. I didn't want to jump in if you do. I understand that there is a member of the council that is asking for an apology for how they were treated during this process. I would venture a guess that we deserve one as well, if that's going to happen, to come back at us. And Jill, to your point, we started on this more than a year ago. So we are in our, I think, 13th, 14th month on this topic. I think that the compilation of things, if not perfect, as Commissioner Welch just stated, at least gets us back into reality. Posting a good neighbor notice on the door and hoping for the best was ridiculous. So I appreciate the work that went into this. There's a couple things that I have questions on. One is the entities. So whether or not you can do, and it doesn't address this in this new version, but can this become a monopoly? Can we have somebody that is buying up houses that are, if you form an LLC, that you can buy as many as you want? That was a question that came up over and over again in front of council during that deliberation. The other is the license fee, and Director Wright, you brought this up. How is this going to be monitored? This basically creates 30 more businesses within Lake Stevens, and who is going to take on the task of making sure these 30 businesses are going to be in compliance. And then there was a discrepancy between what Commissioner Connor Davis stated and Jill, what you stated is the bulk of the responsibility of this ordinance is going to be on waterfront residents. Whether it be 10 of our 30 or 7 of our 30 or half of our 30, it still is the bulk on the waterfront. And I again plead that that's going to be something that needs to be kept in mind as we come to the hopeful final finish line of this long-term and painful deliberation. It was made much more difficult than it needed to be. And I appreciate where we've gotten thus far, and I look forward to seeing it come true to its end. Thank you.
So just a couple of quick responses. As far as limiting entities. We can't control as a city who purchases and sells property and to who you sell it to. There are examples of corporations that have bought up a whole single family neighborhood and they rent those. We can't prohibit that type of ownership. And if someone forms an LLC, drops the LLC, reforms as a different LLC, we're never going to be able to keep in front of that. So that became the goal with the committee. Then what are other ways to control that? That's where they came up with the idea of a cap. You can definitively control corporate interests through a cap. You can definitively control the effect on a neighborhood through separation, that you can't buy an entire block and turn it into a different type of housing stock. So that was some conscious recommendations on their behalf of how to address corporate interest.
May I pause then right there? Because I was hoping that you would say that, to ask the question as to whether or not there's any capability of saying a cap on waterfront versus everywhere else.
And there in the recommendation, there is a cap on both. So the recommendation from the group started at 50. And by the end of the discussion, it was down to 30. And with the caveat, no more than 10 of that 30 can be in the waterfront residential zone.
You answered my question.
Does the waterfront residential zone cover both sides of
Yes,
Lake Drive?
portions.
Yeah.
And then as to your question about licensing fee, there will be a fee that's established that's represents the effort that goes into processing that permit. We will be establishing a database to keep track of these. And we will monitor that to make sure that the cap is upheld. We'll monitor that to make sure that we're getting annual updates to that. And then there will be a fee for an updated license every year. It won't be the same fee as the initial application, but there will be fees commensurate to the work involved to administer those applications.
Okay.
And then we've already touched base on the cap. Joel, did you want to add anything else?
Commissioner Holt, did you have any questions?
No, you guys have actually asked the questions I was gonna ask, so we're good.
I think from my last piece, I just wanted to express my appreciation to staff and also to those who volunteered to be on this short-term rental committee. It was a long process and oftentimes there was a great deal of disagreement. But I think I just want to say thank you to them for their time, for their energy, and for bringing it before us now to the commission with their recommendation.
Does this
I had
come
no
back
further-
to us now? Is this back for a public comment in front of planning commission?
No, the next step is back to the city council. They haven't opened
But we don't
public
get,
hearing still to finalize this, so it does go back, but we're hoping to have a good conversation tonight with the planning commission and at least get a head nod that you approve of the regulations as drafted. And if you have any refinements that we can forward those on to the city council as well to consider as part of any future public hearing.
I am in error. I thought that we were having a public hearing.
I
Hear
thought
about
so
that.
too.
Is it? It's just right back to the commission, council then?
I think they sell their public hearing open, don't they?
Yeah.
Yeah, they never close their public hearing.
Well, if this is going to be the final that is in front of planning commission, what I will say is that I apologize for nothing. I think that this merited spirited discussion, but it got needless at some point. So I hope that city council will heed the combined efforts and finalize this. And then I hope that the city will take it from there and learn from other cities that have erred and not gotten in front of this issue. So with that said, summer is coming and let's get this done. Summer is coming again and let's get this done.
I'll just say, I want to thank Chair Dewar and Commissioner Connor Davis for being on the committee. I know I asked them to do it and they did, and I want to thank them for jumping on when that happened. I'm not happy there was a committee created. I made that point at, I think at our joint meeting. So I'll just make that as my one comment is, I was not happy that the committee was created in the first place. I think it should have just came back to us originally and gone through the whole process again. But, yeah, it is what it is. I'm ready for it to move on and tackle bigger and better things for this commission anyway.
Russ, do you have a sense of when this will be back before the city council?
The city council will see this on February 21st. And then I think the hearing is set. Well, we haven't set the hearing date, but it would be probably early March.
That's great.
And all those on record will be made aware, correct?
Anything else before we move off of this item?
One last thing, there's that idea that misery loves company. We can at least be assured that every other municipality that has gone through this process, it has been equally laborious. It has been, there have been plenty of speed bumps along the way. Again, just like Commissioner Dewar said, really appreciate the work that staff has done to work on the consistently rewriting this, getting us all the information that we need. I still have, Jill, your spreadsheet. This is like my favorite spreadsheet of the year that you created. I really appreciate the work that you put into all the materials available to us, and really that at the end of the day, if Commissioner Dewar brought it up the last STR meeting that we had, this has become distilled down to the point where the real check that we have is in setting that cap, and that being a little bit more aggressive in bringing it to 30 would hopefully dissuade corporate entities from coming in. We know that this has dramatically transformed a lot of cities around the country. Fortunately and unfortunately, Lake Stevens is not like a big bustling metropolitan area. I just again really appreciate the work that's been put into this, and I feel good about where we are moving forward with the code. I appreciate you guys.
Okay. Thank you very much. And that brings us now to item 6, Commissioner Report. So let's go around the room. Commissioner Jen Davis.
Nothing for me tonight.
Sure.
I will pass. Okay.
And nothing for me. I'm good.
Very briefly, our local business was hacked over the weekend. Our network was invaded, and we have had invoices created on our behalf and sent to our customers illegally. The police department has done a miraculous job in opening up a fraud account or a fraud investigation and shutting down the bank account that they were trying to get people to send money to. But what my concern is, of course, is that I'm using personal equipment for city business, and I want to renew the question to staff as to whether or not there is any sort of precautions that can be taken. Security, I'm hyper alert right now, and don't want any of my colleagues to go through the level of pain that we have been through in the last 5 days. So I open that up to discussion or not, but please be aware that it's rampant, and businesses such as ours are prime real estate for people that want to do harm. Thank you. Oh, I'll need this. Anyway.
Commissioner Connor Davis.
So on a different note, there was a group of 5th grade, 3rd through 5th grade Sunnycrest and Mount Pilchuck Elementary students that took their they had quite a bit of time off this afternoon. They took advantage of the sunny weather and went around and picked up litter and garbage around the north end of the lake. Yeah, it was awesome to see some of the images some friends sent over to me of students that were out volunteering their time to help clean up our city.
Thank you, Commissioner Davis. I think for my part, I just had one question to staff, and that's do we need to do an annual PRA training? We good on that as commissioners?
Yeah, I don't think. No, we haven't done an annual training, but if that's something desired, we can.
I only ask because I only ask because I know that there's a state level law that commissioners of all stripes need. I think it's every other year. I'm not sure the last time we did it.
Yeah, let me look into that with
Is that every term? I don't know.
I also know that we have some commissioners who probably didn't catch the last one. Just saying. And with that, I think that brings us to the planning director's report.
Yep, just a couple of items for you tonight. So we have, I just wanted to talk about future agenda for March. Going into March, we'll have the public hearing to set the 2023 docket. We'll be coming back with an introduction to the solicitor's license updates, code cleanup, update on our Lake Stevens Industrial Center, and an update on the climate action plan. Probably we'll need 2 meetings in March, and just wanted to check with the commission if you would prefer to have 2 meetings or to try to jam pack all of those things into a single meeting.
I'm good with either 2 meetings or 1, whatever the group wants to do.
I'm with, Linda's. I'm available for both or.
Yeah.
Along.
Okay.
What might be best for staff time and resources in terms of preparing for those meetings?
A couple of them will be pretty easy. The solicitor's license and the code cleanup will take a bit of time. Look to Jill because she'll be doing one of those to see where she's at.
Yeah, so I don't have a preference as to whether it's in one meeting or whether it's, in 2 meetings. I think that we do a little bit later, so if that could be at the later meeting, that would be good.
And if you're not ready, we could move that one to April as well.
If we did for 2, if we want to book it for 2 and we can do it in 1, that's great too.
Okay.
Are we looking at first?
Yep.
I will hold the dates, but I always like 1 meeting.
Okay.
I mean, concise is good, so, but I think we're all in agreement that if it needs to go 2, we can do that.
And then just the second briefing, just to let you know, we have retained a consultant to work on our climate action plan. So we're getting going on that. They're getting started on the public engagement portion. Likewise, we're ready to go out for secondary public engagement on our Lake Stevens Industrial Center plan. So we'll be bringing those items back to the commission in more detail.
Because the state's requiring the climate mitigation plan, correct?
It is not a mandatory element this time, but it will be in the future, but they offered funding,
I was about to say, do they offer funding for this?
to do it now. So we decided we would go ahead and go through the exercise.
What is the commission's extent when it comes to the climate mitigation plan? What sort of authority do we have within that?
I don't know yet.
Okay.
I'll let you know. Definitely advisory as it affects goals and policies in the comprehensive plan.
Do we have a new planning commissioner?
A planning commissioner has been selected through interview process, and that's been forwarded on to the city council. And so once they take action, a new commissioner will be seated.
And Chair Dewar, were you in on those discussions?
I was.
Excellent.
Any other comments from the planning director?
No, not tonight. Thank you.
Do we need to unexcuse Connor since he joined us for the record?
You can just probably reflect in the minutes that he came in later.
That sounds great. Please do. And with that, that brings us to item 8, adjournment. Do we have a motion to adjourn?
So moved.
Second.
All in favor?
Aye.
Motion is carried. We